Hello, everyone. Welcome to another episode of Gray Matter. Well, when they do market studies and they ask people who hire lawyers what their main complaints are, it might surprise you to learn that the main one that they always get is that the lawyer talks over their head, that they don't understand what's going on, and that lawyers use big words. Well, we have today on the show one of Canada's top legal scholars. And one of the things that he's so great at is taking complex legal ideas and making them really readily understandable in a way that makes it clear really what's going on in the law. He's also a very astute observer of what's going on in the Canadian polity, and his name is Bruce Pardy, Professor Bruce Pardy. Thanks for being on the show today, Bruce.
Leighton, thank you very much. Always nice to be with you.
I've been looking forward to this conversation. There's so many great topics that we can dive into. But before we do that, as we always do, we're going to start with some framing aphorisms. The first one is from Aristotle, who wrote many things. One of them was law is order and good law is good order. Be great if the Trudeau Liberals would follow that one a little bit. The next one is from Thomas Jefferson, who wrote, when injustice becomes law, resistance becomes duty. Next, from St. Augustine, who wrote, it seems to me that an unjust law is no law at all. And finally, from Jeremy Bentham, the great English philosopher, the power of the lawyer is in the uncertainty of the law. Who do we have on the show today? Well, Professor Pardy is a classically liberal legal academic for whom equal application of the law, negative rights, private property, limited government, and separation of powers are foundational to the Canadian and Western legal tradition. He's a critic of legal progressivism, social justice, and the discretionary administrative state. He has written on a range of pressing legal subjects at the front lines of the culture war inside the law, including environmental governance, climate change, energy policy, human rights and freedoms, professional and university governance, property and tort theory, free markets, and the rule of law. He's taught at law schools in Canada, the US, and New Zealand, and practiced civil litigation at a top Canadian firm, Borden Ladner Gervais LLP in Toronto. He's also served as an adjudicator and mediator on the Ontario Environmental Review Tribunal and has published and commented widely in traditional and online media. He serves as senior fellow at the Fraser Institute and helped to birth the Runnymede Society, a branch of the Canadian Constitution Foundation. And he spearheaded resistance to an ultimate repeal of the Law Society of Ontario's Statement of Principles, SOP policy, that required Ontario lawyers to attest to their ideological purity to maintain their license to practice. I don't know of any lawyer who's ideologically pure. I'd like to meet that lawyer. He's also one of the co-creators of the Free North Declaration, a public petition and movement to protect civil liberties in Canada from COVID-19 irrationality and overreach. And he speaks broadly about that and related topics. He's also, understand he's on leave from Queen's Law to serve as the executive director of Rights Probe, a division of the Energy Probe Research Foundation, which is one of Canada's leading public policy and governance think tanks. So, Bruce, welcome to the program. Very exciting to have you on. First of all, for those who don't know, I wonder if you could tell us a little bit about your work at Rights Probe.
Yeah, by all means. So we're a very small law and liberty think tank. And the mandate that we've given ourselves is to try to explain the ways in which the law works and how the law works and how it doesn't. And the latter is becoming more and more apparent to more people, I think.
Mm-hmm.
It started to become apparent to a lot of people for the first time during COVID.
Mm-hmm.
But the thing about that the curtain being pulled back during COVID is that it was pulled back on a whole lot of things that were already there. They just became a whole lot worse, a whole lot more acute during COVID. And so what we try to do at Rights Probe is to dive into the ways in which we think the law is supposed to work, and then the gap between that and the way it actually does work, and to try to bring people up to speed on the ways in which they've put faith in the legal system, not always in a way that has come to work out. And it's a very sobering time for this kind of discussion. It's long past due, long past due. And one of the silver linings of COVID, perhaps, has been that more people are having this kind of conversation.
Hmm.
But in many ways, the legal ground has been shifting beneath our feet for quite a while. But now you can feel it move.
Hmm. I've had this sense, like you, for a long time, that sort of the sands have been shifting. But it's very striking. Some of the things that we're seeing are really I couldn't have imagined. And one example you mentioned about COVID-19. One thing I'd like to ask you about is our Supreme Court of Canada, as you know, has this very special role of clarifying the law nationally and dealing with really important legal subjects, societal subjects that affect most Canadians, perhaps all Canadians. But they have persistently and steadfastly refused to hear any case involving COVID 19, even appeals from the British Columbia Court of Appeal and Manitoba Court of Appeal uh, over things like lockdown restrictions, which affected millions of people in those provinces. And indeed, it affected all Canadians. So, what is your take? Why is the Supreme Court of Canada so reluctant to hear any case involving an assessment of COVID 19?
That's a really good question. To tell you the truth, I'm not surprised that they have turned these cases down. As we both know, the legal experience during COVID was not pretty. There were several cases that were brought that should have been winners, should have found charter violations, and the now, mind you, not all of them, not all
Mhm,
the cases were sound, but many of them were, and the court steadfastly refused to go there.
mhm,
And I have the sense, and it's not based upon very much. Of course, they don't. The Supreme Court of Canada doesn't give reasons when they turn down a
mhm.
leave to appeal,
Yeah.
so we're left with a lot of guessing. But my theory would be that they just don't want to touch it. Some of the things that courts did during this period were very questionable. The reasoning was questionable. The conclusions didn't make sense. And if you're the highest court and you're aware that maybe things didn't fit together extremely well, but you don't want to change the outcome, then the safest thing for you to do is just leave it alone
Mhm.
and not wear it yourself, not get into the weeds of it. Just, the thing is over. It's passed us by. The holdings were what they were. What good will come of us waiting in there and trying to uphold what happened and yet having to correct maybe what the mistakes were? There's just nothing in it. Let's just not do that.
Mhm, mhm. I totally agree. I have the same sense that it's a case of it's your baby, you rock it, where the Supreme Court of Canada is saying, look, governments, you really messed up. You made some really bad mistakes. Oh, they're not saying it without saying it. And as you say, they don't want to come in and sort of try and make sense of this, try and make chicken salad out of, chicken, what.
Right.
But the problem is COVID's not going away, is it? I mean, we've got a government in Nova Scotia right now that is about to pass a new bill that astonishingly is going to give the government, provincial government, entitlement to have access to everyone's
Right.
private medical records. And this
Right.
seems to be you in our opening, you were very unabashedly say you're against progressivism. This seems to
Yeah.
be a progression from COVID laws. Would you agree with that assessment?
Oh
And
yeah.
do
Oh,
you have
no
some
question.
concerns about that law?
Oh, absolutely. So you and I and others said this from the beginning, which was that COVID itself would go away, but we'd be left with the legacy, the legal legacy, the governance legacy that the thresholds were breached. And now
Mhm,
that they're breached, we're not going back to where we were. Now that's the new standard. And so the governments are carrying on as though COVID or COVID like scenarios are still a thing, even though COVID itself has faded into the background.
mhm,
And yeah, so the liberties and I I use that word reluctantly, I suppose, the liberties that the government are taking now with matters that before would have seemed to be a little outrageous. Now people are maybe not noticing so much. So let's
Mhm.
just describe what's at stake here again. In Nova Scotia, and Nova Scotia, by the way, is not the only place that this is under
Mhm.
consideration,
Mhm.
but Nova Scotia is considering allowing the government to access your personal health records. Why? Well, you know, research or tracking of population trends or who knows. But the idea that the government should insist upon having your personal information, I'm not sure that before COVID, people wouldn't have reacted like, well, that's not right. Now we'll see,
Mhm.
because part of the COVID experience has been to condition people to think that this kind of oversight is necessary in order to protect the population from, you know, all the bad things that might be coming down the pike.
Mhm.
But
Mhm.
it's a reflection to me of the breach of the threshold or the
Mhm.
thresholds plural
Mhm.
that we had before COVID. Now we're in a different place.
Mhm. You know, when I was reading about this new law, it reminded me of a case involving a judge whose name is Britton. You probably know about this. I
Yes.
believe she's in New Brunswick, and
Uh-huh.
she was on maternity leave, and she's now resigned, and she's suing over this. She's suing the chief judge of the court, but in her pleading, she actually says that she was on maternity leave. She would not reveal her vaccination status. This is during the height of COVID, and
Right.
that the chief judge of the court actually contacted her doctor and
Mm,
said, "I'm the chief judge. You have to tell me whether or not this person, the Judge Britton, is vaccinated." And so it's sort of when I connect those two stories, it seems to support what you're saying about this this sort of degeneration, this whittling away of our fundamental legal rights, not just the ones in the charter, but even things like the our right to privacy, which I guess is constitutionally protected. But there's this time honored understanding that in statute and really in tradition that the relationship between a patient and a doctor is protected. It's sacrosanct, and it causes me to have concern about comparable relationships like solicitor client privilege between a lawyer and a client. Do you share my concern about this?
oh, absolutely. In a way, one could interpret this as just one more indication, one more step in a very long path from a trend that's been in our law for quite a long time. Now, nothing happens suddenly. It's very slow, but
Hmm.
this really is a the ascension of the idea that public interest trumps individual rights.
Yeah.
That because the government might need your information, or for that matter, the chief judge might need to know the provincial judge's information in order to protect the group, means that, I'm sorry, I mean, yeah, you have individual private information, but really we can't leave that in your hands because we really need it.
Hmm.
Necessity, is the refuge of tyrants. It's
Hmm.
always been the
Hmm.
case.
Yeah.
But 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 the rationale of public interest, even when it's really not acute, it's just really not acute. It'd be bad enough if it was acute. I'm not
Hmm.
saying acute public interest is sufficient, but when the public interest is even not that acute, it is still providing the rationale for insisting upon the release of that which should be and once was regarded to be personal and private.
Hmm. Hmm. This reminds me of a quotation I saw the other day. This is from former President Eisenhower. He said, "If you want total security, go to a prison. There you're
Right.
fed, clothed, given medical care, and so on. The only thing lacking is freedom."
Yes,
But
that's right. And
yeah.
you'll also be very well, in theory anyway, you'll also be very safe in prison. Maybe not from not for your fellow inmates, but certainly from all the dangers from outside.
Yeah, yeah.
So it's still
But
not a place you want to be.
no, but it sort of begs the question of, is our society becoming prison like? Is that sort of where we're going? Another example of this that's happening right now in Canada, I know that being in Ontario, this is something that you probably know a lot about. Several years ago, Dr. Jordan Peterson rose to public prominence when he spoke out about compelled speech, forcing people in Ontario to use preferred pronouns when addressing somebody who identifies as non-binary or the like. And he warned at the time, and I watched this interview recently, and it was so prescient. He warned at the time that this was the beginning of a slippery slope. And now here we are in 2024, and we have the Minister of Justice introducing a bill C-63, which describes online harms, but actually is hate speech laws. And we've seen how these have worked in places like Australia and Great Britain, and it's truly horrifying. Do you want to talk about this a little bit and why Canadians should be concerned about this legislation?
Yeah, sure. This is yet another one of the Trudeau government's horrible ideas. It may be the worst one of all. I don't know, but C-63, and you mentioned other jurisdictions. It's happening, as you say, but also in still other jurisdictions. I mean, Scotland sounds like a bad place now for this kind of thing. Ireland, maybe Germany. It's funny how it's all happening at the same time.
Mm-hmm.
But in any respect, C-63 is, if you like, the return of the old Section 13 of the Canadian Human Rights Act, which existed for a while and then during the Harper years was repealed. This is essentially a section that says that you can't discriminate in your speech, and because it's a federal law, it will apply to telecommunications, which means the internet. And the wording of this version of it refers to hateful speech, which there's an attempt in the legislation to define that, and basically so that they can say, well, we've defined it. But if you read the definition, nobody can possibly know what it's going to mean when it's applied to future cases. It says, well, it's this, but not this. And the distinction between those two things is anybody's guess. So what you basically have is an open-ended prohibition on speaking in a way that might get you into trouble with the Human Rights Tribunal.
Mm-hmm.
And part of the fault of all this, I mean, obviously, it's the Trudeau Liberals for introducing the bill. And by the way, it's got a whole bunch of other bad ideas we can talk about as well. But part of the fault here, in addition to the government, is frankly the Supreme Court of Canada, who, as you will know, a number of years ago, along the way, has said that it's okay constitutionally to have prohibitions on speech on the grounds of hate. And in fact, some of the words in C-63 are taken from judgments of the Supreme Court of Canada saying, well, that's okay. So the people who have said about C-63, well, this has got to be unconstitutional. Now, maybe some parts of it will be, but this part's going to be a hard go, because essentially Supreme Court of Canada arguably has already said, wait, no, this is fine. So we're now in a situation where if this goes through, people will be able to complain about your online speech, make a complaint to the Human Rights Commission, the federal, the Canadian one. They can do so without a lawyer. It's easy to do. The commission and tribunal might decide that you don't get to even know who it is that's complaining about you. You have to hire your own lawyer. You pay them the fees. You have to take the time to defend yourself in this sort of Kafkaesque process. And at the end of the day, if you happen to lose, then you're going to end up owing the complainant and anybody else who you've allegedly harmed, even though they didn't complain, $20,000. And then to make matters worse, the government can sign up for an additional 50. So this is easy pickings for someone who wants to cause a lot of trouble, for the sort of the online trolls who want to get you into trouble. It's just a bad idea
Hmm.
all around.
Yeah.
So let's just hope it manages to get defeated on the
Yeah.
way
It
through.
it sort of applies the old adage, if you want more of a certain behavior, incentivize it. And it seems as though the interest here is to create a society of informers. But
Sure.
the bill that's going through, another, I should say, another bill, not the other, another bill that's really
Yes.
concerning
Right.
is
Yeah.
Bill 367, which was introduced last November by the Bloc Québécois. And
Hmm.
this is the one that deals with really suppression of religious freedom on one view of the matter, which would make it offensive or actually punishable criminally. And just for quoting scripture, it would remove a protection, I believe, in section 319 of the criminal code, which is a defense, an exemption to the charge of hate speech, if you were defending on the basis of scripture or some sort of religious document or theology, for example, the Bible or the Quran.
Hmm.
So that bill seems to go hand in glove with C63 and some of the other bills that this government has been passing aimed at suppressing speech. So I want to ask you a question that might seem obvious to
Okay.
some people, but I think needs an answer. Why is this government so interested in controlling our speech and what we can say, where we say it? Why are they so interested in that, in your view?
Well, it's a logical extension of a philosophy. I mean, let's call it an ideology if you want to, but it's a philosophy. It's the idea that it is the government's job to order things, to supervise, to manage, because the people are really not able to do that themselves. And because we, the aristocracy, if you don't want, if I can use that word, know better, then it's quite all right for us to decide what it is you can and cannot say. It's really a view, of course, um, based upon a profound kind of arrogance, but it's also not that unusual. I mean, governments throughout history have been based upon this idea, and we have lived under a managerial state for decades. And
Mhm.
frankly, although it's bigger now than it ever has been, all the way along, it has still been based upon the same kind of idea, which is, look, there are those of us who really know what we're doing. We know how things ought to be. We don't really want you plebs deciding things for yourself. So more and more over time, we are going to supervise and direct and control and prohibit more and more and more because you're really not doing things very well yourself. And if you take that idea to its logical extreme, you get exactly what we're getting now, which is, well, you really shouldn't say that. You and this C63 is not that the so-called disinformation bill, but that's been discussed as well. The idea that you shouldn't be entitled to say things online which the government would classify as mis or disinformation. In other words, according to them, it might not be correct. In other words, they don't want to hear it.
Mhm.
So we're in a very bad situation. But if I can raise another bill, I'm not sure how you feel about this one, but it's sort of on the same page, if I can put it that way. But its source is very different. It's a private member's bill that started in the Senate, and
Mhm.
it's a bill that the conservatives apparently have supported, at least until recently, and the liberals have been against. And it's very odd that way because it's juxtaposition to the other government bills. This is a bill that has as its stated purpose to prevent pornography from being available to minors,
Right.
which is
Yeah.
a laudable purpose.
Mhm.
But the mechanism that it wants to put in place is to require pornography sites to actually take your personal information in order to certify that you are above the age of 18. In other
Mhm.
words, this is the taking of personal information of another kind for
Mhm.
that purpose, and it is also a violation of your privacy and your anonymity and your freedom of speech, if you like. and yet it's a bill that's being supported and opposed by opposite parties.
Mm-hmm.
And so this idea that there is a higher power that should be deciding what goes on is widely shared in different ways, and it gets expressed in different ways. And there's nothing worse, I think, on the table right now than C63. But even so, it's not a black and white thing. The real problem is that too many people who govern us think that their job is to supervise how we carry on.
Mm-hmm.
And
So what
that
you're,
and
yeah,
and
yeah.
that applies to all the political stripes, I'm
Mhm.
afraid.
Yeah. So what you're saying is that these bad ideas coming through with legislation, Bill C63 is not a one course meal. There's actually a buffet being presented,
Yeah, yes,
which
yes, right, exactly so, yes.
so coming
That's right.
back to Rights Probe, when I
Yes,
asked you about Rights Probe, you said that part of its raison d'etre is um, to make people understand how the law actually works versus how they might think it works or how it should work.
right.
And one of the best examples of that, what that we're living through right now, seems to be the utter failure of the charter to protect individual rights and freedoms in the way that we all expected it to prior to COVID-19. So why is this happening? Why is it that the charter it seems to be unable to protect individual rights and freedoms in the face of really, really obvious government encroachment? That seems as though governments, I shouldn't say governments, political parties of all stripes, as you put it, are just being very brazen about designing bills that clearly offend protected charter rights. Why isn't the charter protecting us, in your view?
It's a terrific question, and there are lots of reasons. Let me just talk about a couple. The first one is very basic, and that is that the charter, unlike what I think a lot of people believe, the charter is not the starting point for our legal system. The charter is not the idea that our system is based upon. The charter is an afterthought. The idea that our system is based upon, and there's more than one, of course, but one of them is legislative supremacy,
Mm-hmm.
meaning that legislatures can make any laws they want about anything. And sometimes people are shocked when they hear that because they think, well, there must be, there's just some things that they can't do. Not true. Not true. The default position in our legal system is legislatures can do anything they want. And then this charter comes along and says, oh, but except not that. So it's just a gloss
Mm-hmm.
on the default position. But what that gloss means has been handed over to the courts. So we have now a combination of legislative supremacy, where Parliament and provincial legislatures can do anything they want, along with a good dose of judicial supremacy. And now the courts are deciding things, especially the Supreme Court of Canada, deciding things in a way that nobody else can have any say over. So they're interpreting the words of the charter in the way that they want, and have been doing so since the charter was brought in the 1980s. And in some cases, you can trace the ways in which certain of these sections start with their text, and if you just read the text, it would seem to mean a certain thing, and then you watch the jurisprudence over these past 40 years or so, and you think, wow, I mean, that's not what I would have thought, right? And so you have that phenomenon going on, but there's also a third thing, which is this: the charter rights, not only do they tend to be very vague, so that the meaning has to be filled in by the court, but they're also very blunt in the sense that in order to be violated, there has to be something sometimes pretty blatant.
Mm-hmm.
So let me give you an example. We had these vaccine passports,
Mm-hmm.
and that was a government program that was basically a government stipulation that in order to, go to a restaurant or go to a store or wherever, you had to have a vaccine. It's to be able to show at the door that you had a vaccine. And people said, oh, violation of Section 7. Life, liberty, security of the person. You're not allowed to require me to be vaccinated. That's a violation of my security of the person, which encompasses some idea about informed consent and so on. Probably not so. because that's not actually a violation of your informed consent. And this is the story the government told from the beginning. They'd obviously worked it out. They worked it out so that it would essentially require you to get vaccinated without requiring you to get vaccinated.
Yeah.
So what they did was they slipped in between the cracks of the charter, and those cracks are pretty big. They went around the back door. The administrative state took control of the situation, but not in a way that was blatant, in the sense that they said, you will get a vaccine or we will arrest you and throw you in prison. They never said that. That would have been a violation of Section 7. They did it a different way. They said, oh, you can decide for yourself whether or not to get vaccinated. And if you do decide to get vaccinated, then you will go to your doctor's office and give your informed consent. But if you don't decide to do that, well, then that's your decision. But you can't fly, you can't go here, you can't do this, but it's still your choice. And the charter proved not to be a good enough instrument to say, listen, that's essentially the same thing. And in effect, they said, no, the administrative state can do it this way so as to avoid charter liability, because after all, that's in the public good.
One very interesting analysis along these lines is from an Alberta historian named Michael Wagner, who wrote a great book. It's called Leaving God Behind. And one of the part of the thesis of the book is that what happened through the charter, and he believes this was intended by the framers of the charter, principally Pierre Elliott Trudeau, that it was a mechanism by which the legislative supremacy, which you talked about, which is sort of time honored, it's in the rocks in terms of English common law and parliamentary tradition. That was part of Canadian law, and theoretically at least still is, but it was a transference, sort of a silent transference of power from the legislatures to these courts, these unelected bodies, these people who are handpicked by government, especially by the prime minister, and who are appointed for life. And they now exert and exercise just incredible power, lawmaking power in our country, and in a lot of ways are shaping our country. One example is a recent case you probably saw, Bruce, where a justice of the Supreme Court said, well, no, actually the correct way to refer to a person who is a victim of a sexual assault is not woman, but person with a vagina. So they're actually changing the definition, just the basic definitions of who we are. So do you agree with that thesis, that part of the way the charter worked was to sort of transfer power from legislatures to courts in this way?
Oh, that has been the effect. No question about it. There are some things over which the court now has the final word. No questions asked. I mean, there's still Section 33, which is the stopgap for, if the court goes too far, the legislature can say, well, we're doing this anyway, and, to heck with it. But there are some things outside the charter, like Section 35 of the Constitution Act, which no legislature can touch. When the Supreme Court says this is what it means, then that's a done deal.
And those Indigenous rights you're talking about there, they just exploded. I mean,
Absolutely.
arguably, Indigenous rights now have surpassed the enumerated rights in the Charter in importance, in legal importance in Canada. You could make I think you could make a persuasive argument along those lines.
Yes, absolutely. But back to your thesis, which I agree with. But I have some misgivings in this sense. So I like to tell the story, the long story, right? You start with the king, and the king was a problem. This is way back in England, right? Around, throughout the centuries, the kings were problems because they had absolute power.
Right.
And over a very long, slow process, we took power away from the king and gave it to the legislatures, from the Magna Carta to the Civil Rights Act and so on.
Glorious Revolution.
Glorious Revolution, sure. all that stuff. And that was good, right? Because the legislatures, certainly today are elected, and the king was a tyrant, and the king's now just a figurehead. And so better for the legislature to have the power than the king. But the problem was that over time, legislatures showed that they could be tyrants too,
Mm-hmm.
right? And
Yeah.
they've legislated an awful lot of bad stuff over the years, an awful lot of bad stuff, which is one of the reasons why the Americans created their Bill of Rights,
Mm-hmm.
saying, well, yeah, legislatures can do stuff, but here's the things they can't do. And so the Americans were the first ones to set this thing up, where a system where you've got a kind of judicial supremacy. The U.S. Supreme Court has much of the same role in their country as the Supreme Court of Canada does in ours, and we followed in the 80s with the charter. And so I agree with your criticism. The court has now got the power to decide the final word on a lot of questions that frankly, for my money, it has really made a mess of.
Mm-hmm.
But it's as close to the American model, which has worked better, at least at sometimes,
Mm-hmm.
than ours has. And so here's my criticism. From the beginning, when we started with the king, all we have done is moved power around
Mm.
from the king to the legislature, from the legislature to the court, and now from the court and the legislature to the administrative state.
Mm-hmm.
And for my money, I would like to suggest that that was a mistake. The mistake that we made was not to just move it around. Instead, we should have taken it away.
Mm-hmm.
And then
Mm-hmm.
that leaves you with the question, well, if not that, then what? Where does power lie? If it lies nowhere, what does that mean? And that's a whole big, conversation. But it's the first step in that conversation is, hold on, none of these answers work. That we don't want the power with the king. We don't want
Mm-hmm.
absolute power with the legislature. We don't want the court deciding all the final answers. And we don't want the administrative state telling us what to do. So where do we go?